Good afternoon, ladies and gentlemen. You are welcome to the Football Law Annual Mode round of 16 virtual rounds. We're happy to have you. It's an exciting day, and I believe it's going to be an exciting session going forward. We have the University of Ibadan as the appellants and the University of Kampala International University as the respondents. You are appearing before arbitrator Francesco Macri, for whom I will now hand the floor to proceed with the session.
Okay. Thank you very much, Leo, and welcome to this hearing. And I am Francesco Macri. I will be the sole arbitrator of this hearing. With me, Miss Margot Di Tondo, my ad hoc clerk. So this is more effective as a real cast arbitration hearing. And I would ask to the parties, to the council of the parties, to introduce themselves, and starting from the appellant. So, University of Ibadan, please, can you introduce yourself?
Much obliged. Appearing before this honorable tribunal is T.E. Oyedeji as the lead representative and counsel, and appearing with me is Hai Oluwafemi. And our humble appearance before this honorable tribunal is for the appellant in this case, in person of Power Stars FC.
Okay, thank you very much, counsel. The respondent, please.
Good afternoon, Mr. Arbitrator. For purposes of record, I'm Christine Naluwama, the lead for the respondent, jointly appealing with my co-counsel, Temfma George, and our table counsel, Tamale Joseph. We are pleased to be here, appealing on instructions of the respondent, and in that regard, Nej Komeko.
Thank you very much. Okay, so we are ready to start. Only one preliminary question. If you have nothing to object to the constitution of this panel, please just say yes or no. Appellant.
We have no preliminary objection. We would like to proceed to the substantive case.
Thank you. And respondent?
We do not have any preliminary objection. We can proceed, Mr. Arbitrator.
Okay, thank you very much. Okay, we can start. So let's do some housekeeping. We have 15 minutes for each party and 5 minutes for rebuttal. Of course, if you agree to have, let's say, an extended time, I'm open to your decision. Otherwise, we will stay strict to the 15 minutes, and then, of course, during your presentation, maybe I can ask something about your the content of your submissions, but I will not take count of the time. So you will be 15 minutes. You will have 15 minutes effective. Okay. Can we stay on 15 minutes, or you prefer 20? Appellant?
Honorable, so we would like to ask if our time allocated for rebuttal is within the scope of the 15 minutes.
Okay. Respondent? You're muted.
Good afternoon, esteemed arbitrator. We have no issue in that regard.
Okay. Okay. Just allow me to start the record. Okay, so appellant, 15 minutes from now.
Much obliged and noted. Dear esteemed arbitrator, can we may we proceed with our case?
Sorry, there is. I can't hear you Very well. Can you repeat?
I was asking the esteemed arbitrator, can we proceed to open our case?
Absolutely, absolutely. Yes.
Much obliged. Um, as rightly stated, we are representative of the appellant in this case, Power Stars FC, and I am here with my co-representative, and we are before this honorable tribunal with 5 issues for determination. And our brief of argument has been filed before this honorable tribunal and served on the other party. And from these 5 issues for determination, esteemed arbitrator, I will be adumbrating on 3 of those issues. Issue 1, issue 3, and issue 5. While my co-representative and co-counsel will be adumbrating on 2 issues, issue 2 and issue 4, and he will take the prayers during, and with that we close our case and we'll come back for rebuttal all within our 15 minutes. I will be proceeding with our first issue for determination, issue 1, which is whether or not a valid and binding employment contract was concluded between Ned Kiko Meko, the respondent, and Power Stars FC, our clients, the appellant, despite the club's failure to return a signed copy. Dear esteemed tribunal, this first matter before this tribunal is to determine whether or not the agreement between both parties are indeed binding, and in fact they are in existence. Esteemed arbitrator, at the heart of this issue lies the fundamental question of whether the required elements of contract formation are present in the contract, namely offer, acceptance, consideration, and intention to enter legal relations, and critically, the formal requirement of mutual signatures, which have been satisfied in the context of an international football employment relationship. Esteemed arbitrator, it is the submission of the appellant that the contract between both parties is not valid and binding because an important element is missing, and the important element which is missing is the formal requirement of mutual signatures. In establishing this submission, the appellants rely on 3 heads of submission. The first head of submission, which is the absence of the club's counter signature, that the fact that it precludes any valid acceptance and mutual consent. Secondly, that FIFA jurisprudence and the essentially negotiable doctrine mandates dual signatures for contract validity. And lastly, that the respondent bore the burden of proving contract formation and failed to discharge that burden. Without wasting time, our first head of submission is that there was the absence of the club's counter signature that precludes acceptance and mutual assent. We would like to commend this honorable tribunal to paragraph 5 of the fact of this case, which stated that in verbatim that after an agreement has been done, Ned signed the contract and forwarded it to Power Stars FC for counter signature. However, Power Stars FC never returned a signed copy of the employment contract. Esteemed arbitrator, it is humbly submitted that there was no meeting of minds without dual execution, because contract formation requires a meeting of minds, which is consensus added. And the club signature was the mechanism by which it will have communicated its accent to the full package of terms. More so, esteemed arbitrator, it has been heard several, like in the case of CAS 2017 A5164, citation rightly supplied in the appellant's brief of argument, where the FIFA dispute resolution chamber held that beyond listing the parties, duration and remuneration, an employment contract must bear the signatures of both the employer and the employee to manifest their mutual assent. Dear esteemed arbitrator, this contract indeed has the signature of the employee. However, it lacks the signature of the employer. And with this, together with the cited legal authorities in our brief of argument, it is our submission that this contract is not valid and not binding because it lacks this required counter signature. Moving on to the second issue for adumbration, which is whether or not the unilateral deduction by Power Stars FC for late submission is permissible.
Counsel, sorry. May I ask you something about the validity of the contract? Just I would ask you, how can you justify the payment of the salary with your interpretation of the nullity of the contract? So it is clear from the case that your client, the club, paid some salaries to the player. And so I would like to ask you, how can you connect, how can you justify the payment of the salary in respect of your position against the validity of the contract? Thank you.
Thank you, esteemed arbitrator. The appellant recognizes the fact that there were some conduct done post-offer. That is, some conduct were done after an offer has been made, like registration and like payment of salary that has been rightly recognized by your esteemed arbitrator. However, the appellant submits that these conduct are mere administrative steps and they do not form contract formation. For the payment of salaries, the esteemed arbitrator, the club advance salary and incidental payments under a without prejudice or good faith internal policy. This is done this is done based on good faith and without prejudice principle and of the internal policy of the club. This was done in order to keep the squad operational and to reserve all rights on whether a binding deal existed. Such provisional payments do not equal contract acceptance. They are gestures payments taken back in disputes like this. Last seen is in the case of CAS 2014 A3728, where it was in that case payment under protest. In short, esteemed arbitrator, they are provisional payments that do not equal contract acceptance, and they are gesture payments taken back in disputes like this.
Thank you very much, counsel. Please go ahead.
Thank you, esteemed arbitrator. Moving on to the second issue, whether or not the unilateral deduction by Power Stars FC for late submission is permissible. Esteemed arbitrator, it is the submission of the appellants that the unilateral deduction was fully permissible because of three reasons. One, because of the contractual basis for deduction. Two, because of the invalidity of the captain's waiver. And three, because of proportionality and reasonableness. First, which is contractual basis for deduction. Dear esteemed arbitrator, we would like to commend this honorable tribunal to paragraph 4 of the agreed fact of this case, the last sentence, which says, additionally, Article 6 in this contract stated that payment of monthly salaries shall only commence from the resumption of the preceding camp training. Esteemed arbitrator, any sanction or deduction must trace back to an express or implied contractual provision. Here, the contract and the club's written regulation jointly govern the respondent's obligation. Article 6 expressly stated that payment of monthly salary shall only commence from the resumption of the preceding camp trainings. By defining salary commencement in these precise terms, the parties agree that days prior to resumption would attract no pay. This clause thus implicitly authorizes prorated salary computation based on actual resumption, a principle which has been recognized in case like CAS 2014 A3714, precisely paragraph 42, where a prorated salary calculation was upheld for a player who joined mid-season, and also invalidity of the team captain's purported waiver. Esteemed arbitrator, the respondent may argue that he was late to the preseason, to the season, based on what he heard from the team captains and the head coach. But the appellant would like to uphold that the team captain is not an ostensible authority for the club to state to provide such information. The team captain is not the required mouthpiece of the club. Also, based on proportionality and reasonableness of the duration, this money was deducted based on principle of lateness. The respondent was 10 days late, and on the principle of prorata alignment, this 10 days lateness constitutes 33% absence, and combined with the preseason training underperformance, this prorata alignment has been used in cases like CAS 2014 A3714, and with this, the appellant rightly deducted 500,000 naira from the appellant from the respondent's salary based on lateness and based on this prorata alignment. I'll be moving on to the third issue for adumbrating, which is whether or not the FIFA Dispute Resolution Chamber has jurisdiction to decide the dispute and issue his default award. Dear esteemed arbitrator, it is our submission that the FIFA Dispute Resolution Chamber did not have jurisdiction to decide this dispute and to issue its default award. And in establishing this submission, we would like to commend this honorable tribunal to paragraph 5 of the agreed facts, which says that furthermore, Article 12 of this contract provided that in the event of any dispute, only the National Dispute Resolution Chamber (NDRC) of the Nigeria Football Federation (NFF) would have exclusive jurisdiction. Esteemed arbitrator, it is a clause, in fact, it is a fundamental provision of the employment contract between the respondents and the appellants that upon a dispute, the court which will assume exclusive jurisdiction is the is the National Dispute Resolution Chamber. And based on the principle of sanctity of contract, dear arbitrator, all agreements and all provisions of an agreement must be adhered to. And also, under FIFA regulation on status and transfer of players, RSTP, the FIFA DRC may only adjudicate employment-related disputes that possess an international dimension. Article 22B of RSTP provides that the DRC has jurisdiction over disputes between a club and a player relating to employment-related matters where the parties are of different nationality or at the time of the conclusion of the contract have their habitual residence in different countries. Their esteemed arbitrator, the player and the club has their habitual residence in the same country, which is Nigeria. And also, the nationality in this context, since the respondent has gotten an ITC, it means that what, so far as this agreement is concerned, he lives and his nationality in that context is Nigeria. And this is the submission of the appellants for this third case. I will be adumbrating. I'll be defining the proceeding to my co-representative to adumbrate on the other two issues for determination.
Good
Thank you,
afternoon.
counsel. Sorry, I will interrupt the time. You have 4.5 minutes remaining. 4.5, okay?
Yeah, much obliged.
So much obliged, members of the tribunal. And I will be talking on the merit of issue 2 and merit 4, whether the respondent is no longer entitled to the performance bonus for the 2023-2024 season. On this, members of the tribunal, we respectfully hold that and the respondent is no longer entitled to any performance based on the doctrine of estope. As a doctrine of equity, the essence of estope is to mitigate the harshness of the common law, as it was stated in the case of Crab and Aaron. And also, this doctrine of estope has also been given judicial definition by this Honorable Court of Arbitration for Sports in CAS 2011 A2473. And to rely on estope, there are different ways. The statement need not only be expressly stated, as it can also be implied by conduct, as seen in CAS 2018 A5552, that a party cannot act against its own action that created an assumption to another party relying in good faith. The essence of the doctrine of estope is to preclude a party who has made orders to act on his decision from relying on what he has said already. On this, I would like to commend this tribunal to paragraph 11 of the fact, which actually stated that the respondents are not received any performance bonus from December 2023 to June 2024, and the respondent did not do anything, neither does he said anything. Based on this, members of the tribunal, we submit that, and the respondent has reasonably waived his right to performance bonuses, and therefore he should be extolled from coming back to claim the performance bonus for the concluded 2023-2024 season. I will be moving on to the last issue, which is the issue 4, whether or not the unilateral termination of the contract by respondents is lawful. And we respectfully hold that this is unlawful. It is stated in Article 16 of the RSTP that a contract cannot be unilaterally terminated during a competition period. The essence of this is to maintain the contractual stability of a contract, and this was judicially recognized in the case of CAS 2018 A507. On this note, I would like to commend this honorable tribunal to paragraph 12 of the fact, which provides that the 2024-2025 season of the EP of the Nigeria Football League shall start on August 2024, and also the paragraph 16, which actually reveals that he terminated his contract on October 20. Based on this, it was actually during the competition period, and also that he had no just cause to terminate his contract based on Article 14 bis of the fifth RSCB that I said at least 2 months salary. I will comment on paragraph 11 and paragraph 14. On this note, members of the tribunal, we declare our prayers. Number 1, declaration that the fifth allied jurisdiction to adjudicate this dispute. 2, declaration that the default award of 20 March is non and void. And 3, and order nullify the compensation of 40,000 awarded by FIFA DRC. 5, and order that any residual dispute between the parties be referred to the NDRC. 5, that the initial contract of employment between the parties is not valid. 6, and order stopping the respondent from claiming any performance bonus. 7, declaration that the position of fine for late resumption is permissible. 8, declaration that the unlawful termination of contract by the respondent is unlawful, and an order for the award of 50,000 million as compensation for the unlawful termination of the contract by the respondents.
With this, dear esteemed arbitrator, we reserve the rest of our minutes for rebuttals. Thank you.
Thank you very much. You were perfect. 15 minutes. That's okay. Congratulations. So I have, before give the floor to your colleague, I would like to ask you 2 issues. The first one concerns the FIFA jurisdiction. So you are claiming that FIFA had no jurisdiction on this case because of the clause contained in the contract. But my question is, how can you justify your objection in front of the fact that the proceedings before FIFA has already been held, and no objection from you, from your client, has been forward during the first proceedings? So don't you think that your client is in a, let's say, in an estoppel position? So since it doesn't put forward any argument, any objection against FIFA jurisdiction.
Thank you, esteemed arbitrator. I would like to comment this honorable tribunal to paragraph 7 of this of the fact of this case, where it's noted that the attorney of the respondents forwarded the notification of the proceeding of the before FIFA DRC to the mail of the CEO. In short, the submission of the appellants that we did not get the notification for the proceeding of the FIFA DRC, and thereby they passed a default decision. We did not receive any notification of that proceeding, and why we could not raise an objection to the jurisdiction of the of FIFA DRC, and they passed a default decision based because of our absence, and our absence was due to no proper notification, because the attorney of the respondents forwarded a notification of the proceeding to the CEO's email address, not disregarding the fact that the correct correspondence to give such effective notification is the correspondence of the club's email address or the club's legal representative accordingly.
Okay. Thank you, counsel. And the second question concerns the performance bonuses. So again, your position, let's say, based on your written submissions, is that the season is ended, and therefore the player is not entitled to receive that bonuses. But again, don't you think that since the bonuses are a part of the contract, a part of the agreed parts of the contract, don't you think that the request of the respondent is not time barred? So let's say, I would ask you if you can comment on the difference between estoppel and time bar. So, because I think that this is the case.
Thank you, esteemed arbitrator. The appellant recognizes the existence of these two doctrines, estoppel and being time barred. But we would like to remind this honorable tribunal that the doctrine of estoppel is it is to soften rigid rules. Esteemed arbitrator, in the fact from the fact of this case before us, the respondent did not receive performance bonus up to June 2024, and however, he only raised concern about it September 2024. And the appellant, submit and believe that that is enough time to waive this performance bonus because he did not raise it adequately. In the case of in CAS 2011 A2473, Al Shabab Club and Saudi Arabian Football Federation, citation duly supplied in the appellant's brief of argument, the doctrine of estoppel was further defined as a statement or admission that induces another person to believe something and that results in that person's reasonable and detrimental reliance on this belief. The fact that the respondent failed to raise the issue of performance bonus timeously, the appellant reasonably believed that he had conceded to that. So we believe that the time in which he failed to have raised this issue of performance bonus was enough for him to waive the performance bonus.
Okay, thank you very much, counsel.
Much obliged, dear arbitrator.
Sorry. So now we can turn to the respondent team, and you can start whenever you want. I would. Okay.
Good afternoon, esteemed arbitrator. As earlier stated, I'm Christina Luwama, appearing jointly with my co-counsel, George Sefma, and at Kamale Joseph, appealing on behalf of the respondent. At the heart of this dispute, Mr. Arbitrator, lies a fundamental question. Can a professional football player's rights to a fair treatment, contractual remuneration, and access to fair treatment be disregarded by a procedural maneuvers and contractual breaches? This case is not about contractual disagreements. It's about safeguarding the essential rights of a player in the global football community. From the outset, the respondent sought only what any professional athlete is entitled to, which is the right to be paid in accordance with the contract, the right to clear and firm communication from his employer, the right to just disciplinary procedures, and right to seek redress before an impartial tribunal. When those rights are violated, Mr. Arbitrator, the facts are very clear. The facts are very clear. Despite the outstanding performance and faithful good conduct of the player, the respondent was denied his November 2023 salary and agreed bonuses, subjected to unjustifiable response and recourse to his legitimate grievances. When the club failed to honor its obligations, the player exercised his rights under both FIFA regulations and international law to terminate the contract for just cause and to seek justice before the FIFA dispute resolution chamber. As I was allocated 5 minutes of this arbitrary tribunal, and I'll be proceeding to submit on my issue, and that is issue 1 of whether FIFA DRC was a competent forum and complied with the principles of natural justice and fairness in arbitrating this matter. Mr. Arbitrator, I'll break this issue into 5 limbs of argument, and I'll be proceeding to submit on my first limb of argument, and that is default jurisdiction. Mr. Arbitrator, Article 22 and Article 23(1) of the FIFA RSTPs read in tandem, and they grant FIFA DRC primary jurisdiction to entertain matter of an international dimension relating to arising from contractual relationships. Mr. Arbitrator, I'll break this into 2 sublimbs of argument, and that is that this matter was of an international dimension, and indeed there was a valid employment contract or relationship. Mr. Arbitrator, CAS CAS 2016, CAS 2014 Arbitral Award 3816 asserts that for matters of an international dimension, there must be an international transfer certificate involvement. They will depend on the nationality of the parties and not the nationality of the dispute. Pursuant to the matter at hand and pursuant to the facts at hand, Ned being a Ugandan player and currently playing football in Nigeria, and of course, indeed, there was involvement of an international transfer certificate. He ceased to be a national player and became an international player, making this matter at hand of an international dimension. Mr. Arbitrator, when you look at the citizen, Ned is a Ugandan citizen and is a registered citizen of Uganda and not a registered citizen of Nigeria. That alone, he is playing football in Nigeria, and of course, he seems to be he is a player of Power Stars in Nigeria, and his registered citizenship is in Uganda. This alone makes this matter to become one of an international dimension. Mr. Arbitrator, when you look at Article 48 and the principles of Lex Sportiva, the sovereign legal order on the RSTPs underscores that FIFA Football Tribunal serves as an ultimate of final international dispute resolution body. And of course, Ned only exercised his rights he only exercised his rights each player is entitled to, and he tabled the matter before FIFA Dispute Resolution Chamber. Moving on to my next limb of argument. Moving on to my next limb of argument, and that is the decision on own jurisdiction. Mr. Arbitrator, Article 1 of the PRGT provides that any arbitral tribunal has the discretion to decide on whether it has jurisdiction to entertain any matter. And in this regard, Ned Komeko tabled a matter before FIFA DRC, and of course it was in line to determine whether it had jurisdiction to entertain this matter, and of course that's what it did. Due to the discretion granted to it by Article 1 of the PRGT. Moving on to my third limb of argument, that is exclusivity in jurisdiction. Mr. Arbitrator, the arbitration must exclusively grant jurisdiction to a competent and recognized member association DRC. This exclusivity is subjectively against any other internal arbitration body within the locality of the country that may most likely not be recognized by FIFA, but not against the FIFA DRC itself. So the exclusive clause cannot override the jurisdiction of FIFA DRC. The inherent jurisdiction of the FIFA DRC, neither can it override the statutorily provided jurisdiction of FIFA DRC from entertaining this matter. Mr. Arbitrator, moving on to my last limb of argument, and that is the recognized principles of NDRCs. Mr. Arbitrator, for any NDRC to be recognized, it must follow the principles and procedures of FIFA regulations. But however, the appellant has failed to prove that indeed the NDRC of Nigeria followed these principles of FIFA. Among the principles of FIFA regulations, one would be the independently constituted body. That is, NFF could have been independently constituted and indeed could have independently be constituted, and of course needed to be, it had jurisdiction to entertain only national matters. But however, when you look at CAS 2016 Arbitral Award 4846, it clearly states that matters of an international dimension, as earlier stated. However, this matter was of an international dimension and not of national dimension, Mr. Arbitrator.
Sorry, Council, I will stop the time, and I would ask you something about the jurisdiction. Let's assume that I will accept the exception of your colleagues, and then stating that FIFA DRC has no jurisdiction in this case. What should I do in my final decision? Should I just annul the FIFA decision, or should I revert back the case to the FIFA DRC for a new decision? Which is your position?
I beg your pardon, sir?
Yeah. The question is, let's assume that I will accept the exception of the objection of your colleague, and then I will state that FIFA DRC has no jurisdiction in this case, no jurisdiction. My final decision, what should be, in your opinion? Just the annulment of the decision of the DRC, or shall I revert back the case to FIFA DRC for a new decision on this case?
Mr. Arbitrator, you're asking if at all you can overrule the decision of FIFA?
Let's assume that I will annul the decision. I will say that FIFA jurisdiction has no, that FIFA DRC has no jurisdiction. My final decision should be just only the annulment of the FIFA DRC decision, or also shall I, as the arbitrator, revert back the case to FIFA DRC for a new decision?
Yes, Mr. Arbitrator, FIFA DRC had jurisdiction, and I would say that the mere exclusivity in the contract cannot override the jurisdiction of FIFA, since it had inherent and statutory provided jurisdiction to entertain any matter of an international dimension and other matters. So it had a law to protect the rights of the player and all other players in the world football community.
Okay, thank you, Counsel. Please go ahead.
Much obliged, esteemed arbitrator. Once again, I'm George Senfuma. Proceed on the merits of issue 2, 3, 4, and subsequently make prayers for the respondent. Esteemed arbitrator, issue 2 is as to whether Ned's leave did indeed amount to a breach in the contract subsequently. However, esteemed arbitrator, I intend to proceed on this issue under 2 major limbs of argument. That is, actions justifiable, actions out of good faith are once excusable under the law, and the lack of intention to terminate or to abscond in any way. First and foremost, esteemed arbitrator, good faith entails the honesty and obligation and intention to uphold the interests of another party in a contract. It is evident with the facts at hand that Mr. Ned Chikomeko did not in any way act out of bad faith. His actions were stemmed on the communication of an authoritative club leader. This communication came through a team captain or a team leader from the head coach. It is evident and it is right that a head coach has greater influence over who continues to participate in the sporting activities of a club and who does not. The major role of a player in or on a team is to continuously participate in the club's sporting activities over which the head coach has influence. Esteemed arbitrator, the situation may further go out of hand because it may cause a detriment to a player whose employment situation is still uncertain, for them to go ahead to travel to a foreign state and stay there, yet their communication, their employment status is not yet clarified by the relevant or the authorities that went ahead to give such communication of termination. This follows a multitude of cases, for example, Fahad Aziz Bayo, where the player's contract was terminated mid-air due to communication breakdowns. And this led the player into suffering or in a foreign state, and hence any reasonable person, esteemed arbitrator, would believe that indeed the communication is authoritative and to deter any sort of detriment would rely on the same. Esteemed arbitrator, furthermore, living in a foreign country on a work permit for which employment one does not practice does sanction penalties in regard or in view of misrepresentation, among others. Esteemed arbitrator, on the limb of lack of intention, we see that the player, upon being summoned by the CEO of the club, he without reservation boarded and traveled back to Nigeria and resumed his activities with the club. This subsequently shows that he indeed had no intention to abscond or prolong his leave, but he merely relied on the communication of a club leader. However, furthermore, esteemed arbitrator, CAS Arbitral Award 3813 of 2014 emphasizes the importance of sourcing and establishing the intention of the party before finding them in breach of the RSTP. Esteemed arbitrator, we so pray that you find this issue fully proved. Esteemed arbitrator, I so proceed to issue 3, which is the player lawfully terminated his employment contract with a just cause. Esteemed arbitrator, I'll proceed on this issue under 5 limbs of argument. And in that regard, esteemed arbitrator, I intend to rely and to proceed on limb number 1, which is a just cause to terminate, and limb number 2, which is a termination as last resort, and the unjustified salary deduction, and subsequently the inaction did not amount to acquiescence. Esteemed arbitrator, when it comes to just cause, 2 core elements must be proved: the seriousness of the breach and whether or where the bonuses form a fundamental element or material element of the remuneration. First and foremost, the seriousness of a breach was established in CAS jurisprudence, which is CAS Arbitral Award 6889 and of 2018, where it was clearly stated that a continuous and cumulative breach does amount to a serious breach. On the bonuses being part, it was stated in CAS Arbitral Award 5882 of 2018 that indeed any bonus that is included as part of the contractual obligation is fundamental and material. On the termination, there was notice, the club was notified and granted a period of over 20 days to respond, which it didn't. The unjustified salary deduction subsequently shows the bad faith of the club as it failed to follow the procedure for salary deduction. The inaction did not in any way amount to acquiescence. Why? The player's silence, initial silence, was a mere professional patience to wait for the club to comply. I'll then proceed to the prayers for the appellant, esteemed arbitrator, and so for the respondent, sorry, and the respondent subsequently prays, esteemed arbitrator, that this honorable tribunal finds the default judgment of the FIFA DRC valid and be upheld, and that FIFA had no jurisdiction. Subsequently, the FIFA DRC followed the criteria and dismissed the suit with costs.
Thank you very much, counsel. And I have 2 questions for you and for your colleagues. And the first one concerns the validity of the contract. And of course, you know, and that the appellant objects to the validity of the contract since it was not signed by the CEO of the club or any other representative of the club. Which is your position on this fact? Because in my opinion, it has a relevant effect on the contractual obligation, for example, on the bonuses, because the bonuses are something that should be agreed by the party and signed by the parties. But in this case, we have no signature of the contract. Which is your position about this?
I'm much obliged, esteemed arbitrator, and pursuant to CAS jurisprudence, specifically CAS Arbitral Award 3816 of 2014, it was clearly stated that the signature on an employment contract is not a mandatory requirement. It is a mere procedure requirement, and where such a procedure requirement lacks, this honorable tribunal or any other honorable tribunal must look at the intention of the parties. The intention of the parties can be sourced from the conduct of both parties. How did the party conduct themselves post the employment? For example, Power Stars, it is evident that Power Stars FC went ahead to grant Ned Chikomeko the opportunity to work at the club. It granted Ned Chikomeko the incentives that any employer would grant its employee. For example, why would you grant an employment contract? Why would you grant a holiday as an employment incentive to a player who you allege is not your employee? Next, it is entirely based on the intention of the parties, esteemed arbitrator.
Thank you, counsel. And the final question concerns the fine imposed by the club. And I assume from the facts of the case that the player was informed by the head coach Petko Minic through the team captain of the fact that the coach didn't want the player in Nigeria no more. But don't you think that is a duty of the player to ask for an official position of the club and not take for granted just a message from the team captain? Don't you think that is a failure of the player not to ask to the club if he should come back or not? Because reading the facts of the case, the player only was informed by the team captain, and he said, "Okay, thank you, I will not come back to Nigeria." But if you are a player, you have a duty to be informed, and you have a duty to comply with the decision of the club, and of course to ask the club which was and which is your official position.
Much obliged, esteemed arbitrator. And this, of course, it was well known that the commencement of the season was to be in August. And the club had to await any further communication from the club since it was still the August. And subsequently, the CEO went ahead to communicate to the team, to the player on the 30th that indeed he still required, hence terminating the initial communication. However, it is not the duty of a player, esteemed arbitrator to establish a clear and effective communication channel between himself and the club. But it is the duty of the club to establish such clear and effective communication, which Power Stars in the first instance did not do in any way for the full month of August till the 30th.
Thank you very much, Council. So now we can move to the rebuttals, and starting 5 minutes for the appellant. Okay, since now.
Much obliged, esteemed arbitrator. Our first rebuttal is based on jurisdiction, the argument of the respondent as to jurisdiction in this case. Dear esteemed arbitrator, paragraph 4.1, page 12 of the respondent's brief of argument. The respondents relied the crux of their argument on a judicial precedent, which is Mesocovet Zurich Football Club LLC and Antonio Vutox and FIFA. Esteemed arbitrator, appellants would like to distinguish the judicial precedents relied upon from this case at hand. Esteemed arbitrator, in this case, the FIFA DRC held that based on Article 22(1)(b) of FIFA RSTP, FIFA is competent to deal with employment-related disputes of an international dimension between a player and club, and unless they have explicitly chosen to defer such disputes to an independent arbitration tribunal or state court. Also, my esteemed arbitrator, in this case, FIFA DRC held that the club's objection to the jurisdiction of FIFA DRC is primarily based on clause 49 of the employment contract, which refers to 4 different forums: 1, Hungarian courts; 2, MLSC internal bodies; 3, FIFA bodies; and 4, the Sports Standing Arbitration Court, arguing that the parties clearly agree that they must bring their labor disputes before the competent labor courts. Esteemed arbitrator, it is the submission of the appellants that in the case cited by the respondent, in clause 49 of the contract in that case, they had 4 options of forum. That is, clause 49 of the contract in that case gave 4 options of where they can resolve their disputes. And with that, FIFA DRC held that since there are options in the clause, thus the first aggrieved party has the discretion to choose which of the 4 forums he would like to litigate the case in. However, in this case, clause 12 only gave one choice of forum. So since in the case cited by the respondents, there were options which led to the principle of the aggrieved parties choosing whichever forum he would like to, it does not apply in this case. The appellants recognizes the principle of stare decisis non quaete movere, which means that what we should all decisions are binding. Similar facts attract similar decisions. However, this is the submission of the appellants that the decision in that case cited do not bind this honorable court because the cases are different. Moving on the argument on good faith, esteemed administrator, the respondents argued on good faith. The respondent said that Mr. Nerd acted in good faith when he stayed away, having been told by the captain and the coach that he was no longer needed, and therefore any late return deduction is unjust. With respect, this defense fails for 2 reasons. First, the coach and captain lacked any authority to suspend Nerd's obligation or excuse his attendance. We would like to commend this honorable tribunal to CAS 2020 A6798 case between Galatasaray and Ugo Tudor, where the FIFA DRC held that only the club's executive board or another formally empowered organ can alter contractual duties or grant leave. A unilateral instruction from an on-field staff, however sincerely conveyed, is legally ineffective. Secondly, the respondent's good faith belief does not override his contractual duty to observe the club's clear timetable. The preceding camp dates were fixed well in advance, communicated by the club in writing and undisputed. Not only the respondent did not act in good faith by listening to the captain and the coach who lacked the formal authority to give such decision, they also failed to receive it through formal channel by or only by via phone call. Hence, the submission of the appellants that there is no good faith on the side of the respondent because they listened to the team captain and head coach, and both of them lacked the authority to give such information. Also, on the principle of just cause, dear esteemed arbitrator, the RSTP does not define just cause, and what amounts to just cause is determined based on the relevant circumstances. But a perusal look of Article 14B, outstanding wages is a just cause. Yeah, it is paid promptly. According to paragraph 11, it says that the salary was paid promptly. Based on this, there is no just cause. RSTP is clear, and the amount of the respondent lacks no authority or standing. They may say that the unpaid bonuses is a just cause. Esteemed arbitrator, this argument has been quashed by the principles of estoppel. Another thing that the respondents use for just cause is salary deduction. Esteemed arbitrator, we have established that the salary deduction was based on lateness, which relies on Article 6 of the contract. And lastly, on our rebuttal is the counter signature. We would like to retrace to this honorable tribunal that a counter signature is not only a mere requirement, but a mandatory requirement for a contract to be binding between a player and a club. Thank you.
Thank you.
Yeah.
Thank you, counsel. Thank you. Counsel for the respondent, please. 5 minutes. Let me reset the time. Okay.
Much obliged, esteemed arbitrator. Esteemed arbitrator, the appellant relies on the doctrine of estoppel. However, paragraph 2 of CAS Arbitral Award 552 of 2018, which was effectively and subsequently cited by the appellant in their brief, clearly states that the principle of estoppel can only be invoked by a party that did act in good faith, and the one that did not act in good faith cannot go ahead to invoke such a doctrine. Esteemed arbitrator, the doctrine of estoppel does not operate to uphold a wrongful act. The rationale for the application of the doctrine is expressive and clear, that it is to protect the rights of an individual to a contract and not to rob them of such right. And the actions of the appellant, appellant are evidently robbing Mr. Ned Chikomeko of his worked for payment for a period of a full season, and such must be quashed on the prayers of the appellant. Esteemed arbitrator, on the issue of the contract validity, once again, it is not upon the signature or the formalities that have been established, mostly the signature, which is not mandatory, but it is entirely upon the intention of the parties. Did the parties intend to establish such a contractual relationship, and what happened post the employment negotiations and contracting? So, furthermore, esteemed arbitrator, the jurisdiction for one to raise an issue of jurisdiction in regard to FIFA's arbitral proceedings, FIFA must be a party to a suit. However, the appellant in this suit did not in any way append or include FIFA as a party to the suit. This quashes the claim that FIFA DRC did not have jurisdiction, and subsequently quashes the claim that that the FIFA DRC did not properly notify the party, since these are the grounds for which FIFA should and can be sued or included on a charge sheet in any sort of appeal, which the appellant did not rely on. Furthermore, in regard to the exclusivity of the NDRC, it is the burden and entirely the burden of the appellant or the party claiming a right based on given facts to prove such facts. And the appellant has not adduced any sort of evidence to prove that indeed the NDRC of the Nigerian Football Federation complied with the core and minimum principles of recognition established in the NDRC recognition standards and subsequently CAS and FIFA. Therefore, pursuant to CAS Arbitral Award 10725 of 2024, esteemed arbitrator, it was clearly stated in consideration of the FIFA Circular number 101 that when or if a party is intending to prove that the NDRC is competent to entertain the matter, it must
I think there is a technical issue. Sorry, Council. Okay. Try again, because you had a technical issue. You were mute for 1 minute. Can you hear me now?
Yes,
okay. Please, if you can repeat, because you were mute for, let's say, 30 seconds, 1 minute.
Okay. Yes, sir. Much obliged, esteemed arbitrator. I will duly repeat what I said. Esteemed arbitrator, in regard to the doctrine of estoppel, the appellant went ahead to cite CAS jurisprudence, and that is specifically CAS Arbitral Award 552 of 2018, claiming that the doctrine of estoppel is on their behalf. However, it is straight that the principle of estoppel cannot be invoked by the party or by a party that did not act in good faith. Good faith being acting not in a deceitful way or in a deceitful manner, and not intending to mislead another party. The actions of the respondent or of the appellant through his agents and his club leaders or its club leaders show that the club did not intended to mislead the player and did not act in good faith. First and foremost, it communicated that the contract was terminated, it was no longer existent. Later on, it stayed silent without clarity. Then it sourced that the player is still needed. Esteemed arbitrator, the doctrine of estoppel does not operate to uphold a wrongful act. The rationale for the doctrine of estoppel is very, very clear, esteemed arbitrator. It is to protect the rights of a party to the contract and not to rob such a party of their right. Esteemed arbitrator, the refusal to pay the players bonuses for which he has labored to achieve or to attain for a period of a full season goes to the core and the core of the contract and negates and shows or maligns the appellant with total bad faith and deceit. And subsequently, the appellant cannot rely on the doctrine of estoppel pursuant to paragraph 2 of the CAS Arbitral Award as stated. Esteemed arbitrator, in regard to the contract validity.
Sorry, you were afforded with the one minute more because of the technical issue, but now we are out of time. So if you can close your rebuttal.
Much obliged, esteemed arbitrator. Much obliged, esteemed arbitrator. Esteemed arbitrator, this is a very, very problematic precedent if it is decided in favor of the appellant. And this will lead to a wave of disputes where the club goes ahead to waiver their obligations dependent on the players and the subsequent claim that the player impliedly made it believable that they did not want to receive their payment for which they labored for. The appellant is on an expedition to evade taking responsibility for their unrealistic actions. It subsequently acknowledges the refusal to pay the players' remuneration and intends to rely on the estoppel for which they cannot because they are acting in bad faith. Subsequently, esteemed arbitrator, the conscience states or asserts that a laboring employee cannot impliedly waive his right to payment. Much obliged.
Thank you, counsels. So we are at the end of this hearing, and I would ask you if you are satisfied about the way it has been conducted, or if you have any objection. Starting from the appellant, please just say yes or no.
Yes, we are
We are
satisfied.
satisfied, sir.
We have no objection.
Thank you. Respondent?
We are satisfied.
We do not need, we're not objecting.
Thank you very much. So the hearing is closed, and I think, Leo, should I give the feedback right now?
Yes, I would. Thank you very much, litigants. Very amazing session that has been, quite neck and neck, I must say, and must have been an enjoyable one for you, Mr. Francesco. Yes, kindly proceed and give the feedback on the submissions and possibly any pointers that could lead or they may need for the subsequent round.
Okay, thank you, Leo. So, dear teams, I took some notes. Of course, probably they are not exhausting, but I will try to give you some I hope useful feedback. And the first one, just let me open your written submissions. And the first one is for both the team. Please, whenever you want to use jurisprudence, CAS jurisprudence, for example, please quote the phrase that you want to be read by the arbitrators. So not just quote the number of the case, but also the passage, the phrase that you think could be useful. And at the end of your submissions, remember to also put the link to the decision, because, for example, appellant, you quoted a lot of CAS jurisprudence, and this is very, very, and I appreciate, of course, but you can choose if you want to quote just a passage, or if you want to quote the entire decision. So you have to it is better to insert the link to the decision. Let's say, not because the arbitrator, not because there is some kind of indolence of the arbitrators, but just to facilitate, facilitate the reading and the possibility for the arbitrators just to catch the sense, catch the content of your position. This is very important. And on the other side, my congratulations for the written submission, because they are well written, divided in paragraph, and this is very useful for the arbitrator just to understand where we are and where we go. Moving to the hearing today, I will start from the appellant. Okay, good preparation, but slow. Be slow. It is very important if you underline your passage, not just a quick let's say a quick development of the arguments, but give a pause. Let's say get a pause and then move to another argument. And when you want to point out some arguments that you think could be useful for you, please stop, point out them, and then you move. And this is very important for the presentation of your arguments. And this is very important to catch the arbitrators, and let's say, and you will be sure that the arbitrator probably will follow you on your arguments. And for the respondent, good presentation. I would rather say that you should more emphasize some arguments, because it seems that all the arguments for you are have the same value, and this is not because, for example, just give an example. The validity of the contract, in my view, of course, it's very important, and let's say not the estoppel concerning the preliminary bonus, because your position is to be sure that the contract is valid, and then if it's valid, the contract, you don't have to spend too much words on the estoppel of the bonuses, because they are clearly they clearly should be paid by the club. So more, let's say, be sure that you can recognize the arguments, the most important arguments for you and for your client, and then stay strict on them, and because otherwise you have already write whatever you want. You have already used the written submission, so we already have your position, but we need from the hearing something more. Let's say something that can catch our attention. Okay. But by the way, and of course, I understand that probably at the very at the starting of this hearing, there was some, let's say, some excitement. I understand, because it's not easy to stream the before the virtual audience, and for example, your rebuttal, both your rebuttal were very good, and then, of course, finally let me congratulate, because in any case your performance was very high, and again, I would say my best luck for the future.
All right, thank you very much, Mr. Francesco. Wonderful session, commendable session, very good grit therein, and indeed, we'll wait on the evaluations later on, which shall be shared to the contestants in the round of 16. From the Footballer and your Mod, I would like to thank you all, our University of Ibadan, Kampala International University, and our arbitrator, Mr. Francesco Macri, as well as Margot Di Tondo, who was online following up on the proceedings. Ladies and gentlemen, our session comes to an end, and I wish you a wonderful evening or the rest of the day. Thank you.
Thank you. Bye.
Thank you.
Bye all.
Bye.
Bye bye.